leave me unmuted. Thank you. So, ladies and gentlemen, welcome to the 147th monthly meeting of FOSWL. And as is the wanted custom, because we always have some new people in the meetings, I'll take a minute to say what FOSWL stands for. FOSWL. It stands for Friends on Same Wavelength. Friends on Same Wavelength. It was essentially started as a forum for senior citizens. The Hyderabad chapter, of which this is a meeting today, was started in 2009 by my father, in whose name this month's endowment lecture is. But it was started about 20 years ago in Cupertino, California, when the first engineer-in-chief of the then Andhra Pradesh, combined Andhra Pradesh, he settled down in the Bay Area, and finding that there are a lot of people like him from India, Pakistan, Bangladesh, he started this forum there in the India Community Center. And that is the origin of FOSWL. FOSWL Hyderabad is in its 13th year. This is the 13th year. We have never missed a single monthly meeting so far. This is the 147th monthly meeting. And Mr. Venkateswararao, who's the founder president, missed only 2 meetings on both occasions when he was in a hospital bed. Otherwise, most of our members regularly attend all our meetings. So I welcome you all to this 147th meeting. And before we proceed further, may I invite a young budding lawyer, Nihal Kovali. Nihal had done some yeoman service when he was working with the state government in the protection of child rights. Now he is a practicing advocate. He is a very passionate and accomplished debater. He is a prime member of the Young Orators Club, which is associated with YMCA for those of you who are from Hyderabad. Nihal, would you please read the prayer?
Thank you, sir. Let us pray. Heaven of freedom, where the mind is without fear and the head is held high, where the knowledge is free, where the world has not been broken up into fragments by narrow domestic walls, where the words come out from the depth of truth, where tireless striving stretches its arms towards perfection, where the clear stream of reason has not lost its way into the dreary desert sand of dead habit, where the mind is led forward by thee into ever-widening thought and action, into that heaven of freedom, my Father, let my country awake. Amen.
Thank you, Nihal. One of the customs we have adopted in FOSWL is that every monthly meeting is an annual endowment lecture to celebrate the life and work of one of our members. And the month of March happens to be that of our founder president, Mr. Venkateswararao Tipirneni, who's my father. And to speak a bit about his life and work, we have Kaustubh joining us, my son, from New Jersey, who will tell us a bit about the life and work of Mr. Venkateswararao Tipirneni. Kaustubh, the floor is yours. Do you need to unmute yourself?
Yes, thank you. Good evening, everyone. My father, Subbarao Tipirneni, told me that I was going to introduce my grandfather at the start of today's meeting. I was overjoyed, and as the day got closer, I was getting more and more anxious, trying to figure out how I can summarize 92 years of someone's life in 5 minutes. I'll try and do my best. I want to start off by sharing an incident that I still remember and cherish. As a kid, I spent a lot of time at my grandparents' house. My grandmother was a second mother to me, and my grandfather was one of my best friends growing up. One day, after lunch, he was eating a custard apple. I was inquisitive and asked him to teach me how to use a spoon to remove the seeds as he's eating the fruit. He showed it to me and warned me that if I do consume the seed by mistake, a tree would grow out of my tummy. I think the humor connects us too. Even though we are 63 years apart, we always manage to have a good laugh when we speak. In today's world of high speed internet, microwaves, autonomous vehicles, and artificial intelligence, critical thinking, old school values, and morals are becoming ever so rare. Grandfather is a perfect example of a balanced human being. He values the old school ideas, methodologies, while also adapting to the new technologies around him. He called me 2 years ago in 2019 and wanted to learn something over a phone call. He wanted to learn how to zoom into something on his web browser on his computer. This man was 90 years old when he did this. I think it was Google Chrome that he wanted to zoom in. Spent about 20 minutes on a WhatsApp call and he managed to learn how to do it. I do not know another 90-year-old man who's capable of learning the way my granddad is. He's inquisitive, enthusiastic about learning new things, and his never give up attitude is a breath of fresh air. He was born on March 5th, 1929, in Angaluru, which is a village in the Krishna district. He attended the government elementary school in his village and then gained his higher education from a school in a neighboring village of Gudivada. Completed his intermediate in Machilipatnam and went on to earn a BCom degree from the Andhra University in Visakhapatnam. Growing up, he participated in the Quit India movement, where a lot of teenagers from his village resisted the British occupancy of the region. And some even got jailed for their actions. But luckily, they were minors and they were let go. When he told me about the story of his involvement in the Quit India movement, it really excited me to know that somebody from my family was involved in the independence movement. Some of his childhood friends who took part in this still receive the freedom fighters pension, even to this day. He then participated in the Gandhi ashram in a nearby village, Komaravolu. This truly helped him connect with our culture, country, and the struggle of that time. He learned how to spin yarn on a chakra and even started wearing khadi. This was where he had a chance to be mentored by eminent people and politicians of that era. People like Acharya Ranga, Peddireddy Timmareddy, Rajagopala Naidu, Gottu Lachanna, Obbula Reddy, Goripati Venkateswararao, amongst others. Subsequently took an active part in Seva Dal, which was founded by one of his mentors from the Gandhi ashram, Acharya Ranga. It is here where he learned how to practice yoga. And still practices it in his own. My grandfather was also a great singer, and he learned the art of Burakatha, which is the art of oral storytelling through songs. He still sings to this day. He married my grandmother, Srimati Nirmala Devi, in 1951. Together, they have 4 children, 8 grandchildren, I'm one of them, and 4 great-grandchildren as of today. They moved to Hyderabad in 1960 for providing better education opportunities to their children. He was a pioneer in experimental agriculture, where he introduced various varieties of fodder for cattle and even integrated farming with compost pits, water-saving initiatives, and leveraged technology to to gain higher yields. He then transitioned into construction, and some of his projects include ECIL, Central PWD facilities, Hindustan Cables, the rocket launching site at Sriharikota, and Dondakarai Dam. Every time I read about the advances India has made in space exploration, I can't help but feel proud that my granddad had a role to play. As he got older, he wanted to give back. He worked on setting up a reverse osmosis facility to provide safe drinking water in his village of Angaluru. He helped revive the primary healthcare facility in his village and also helped establish a daycare center for senior citizens. He actively participated in the formation of the Kisan Forum as a founder under the leadership of Lakshman Rao Garu, Dr. C.L. Venkatrao, and Ram Babu. FOSWL is established under the Kisan Forum, which is a non-for-profit registered society. During 2001, to a visit to the US, like my father was mentioning at the start of the meeting, he attended meetings of FOSWL in Cupertino, California, at the invitation of Senior Sir M.L. Swami. Impressed by its activities, on his return to India, he founded APTA, APTA, stands for Associations of Parents of Telugus Abroad. He was a founder president. Similarly, he founded FOSWL, Hyderabad, as its founder president in 2009 and has been the guiding spirit behind its growth since then. During the organization's operation of 6 years, he only missed 2 meetings, as my father mentioned earlier. I mean, these are levels of consistency that I know for a fact I can't keep up with. I mean, I was 2 minutes late. I joined the meeting 2 minutes before the start time. So it shows the difference between the generations. Another project he's very proud of is a life convict children's hostel, Samrakshana, that he encouraged and guided a friend to set up near GD Bank. It has 27 children of life convicts and about 25 senior citizens, and has been operating very well since 2015. He is either a trustee or an advisor to the following NGOs and actively participates to this day. The Venkateswararao Charitable Trust, which runs the hostel that I've just mentioned, Samrakshana for the life convicts children. GAG Charities, which provides educational scholarships for needy students. Shamani Foundation, that runs a free hostel and educates about 25 students each year. ANNA, Associations of Non-Resident Natives of Angaluru, which took up development activities in that village. He's the founder president of FOSWL, Hyderabad, which was formed in January 2009. The founder member of Sarvepalli Radhakrishnan Charitable Society, and he's still an active member of the Probus Club of Rotary. As a kid, I used to keep pushing back on conversations about politics, saying that politics is dirty and that there's no hope the way things are right now. But his response was always a patient and insightful one. He always mentioned that we must take ownership of our actions, and then we can bring about a change by starting with ourselves, by doing the right thing, which in turn inspires the people around us. His spirit of never giving up on a fellow human being, an amazing trait that I respect and I'm amused by. His love for the country is unmatched, and his enthusiasm to keep learning about new things tires me sometimes. I'm immensely happy to have spent a significant part of my childhood around my grandparents, and he had a huge role to play in making me who I am today. I think the one thing that really connects us today is our love and pride that we have for our beards. I don't have a beard now, but one of the pictures in the slideshow, I know you can see that he has a really nice beard. I think my grandfather and I have really good beards, and we love talking about it. Who would have thought I could share something like that with my 92-year-old grandfather? His humor is always on point, and his mind is free of trouble and always looking for a new challenge to tackle. His love for his family and the people around him is heartwarming. Tatya, I learned so much from you. Thank you for continuing to inspire me and everybody else around you. Just continue being who you are. You're one in a trillion. It was an absolute honor introducing my grandfather, Shri Venkateswararao Tipirneni.
Thank you, Kaustubh. You can stop sharing your screen. For giving a glimpse of your grandpa's life and work. As Kaustubh mentioned, he celebrated his 92nd birthday on the 5th of this month and has entered his 93rd. So FOSWL wishes him good health and long life, and to continue to be associated with FOSWL and its activities. I now call upon Jayanti Sethuraman. Jayanti was earlier in corporate communications, more on the healthcare side, and now specializes in strategy consulting for various corporates. She is also an ISB graduate, as I had mentioned earlier. She has joined us from Bangalore. Jayanti, would you introduce our honored guest and distinguished speaker for today, the Honorable Justice Lokur, to our audience?
Yes, sir. It would be a pleasure. Good evening, everyone. Thank you, sir, Mr. Subbarao Tipirneni. It is indeed an honor and a privilege to introduce the distinguished speaker for today, Honorable Justice Madan Lokur, former judge of the Honorable Supreme Court of India, for his talk on justice delivery in India needs an urgent makeover. Justice Madan B. Lokur, former judge of the Supreme Court of India, has vast experience of more than 4 decades in several disciplines of law. Some of the major milestones of Justice Lokur's illustrious career include being enrolled as a lawyer in 1977, designated as a senior advocate in 1997, appointed as Additional Solicitor General of India in 1998, appointed as Additional Judge of Delhi High Court in 1999, also appointed as the Permanent Judge of that High Court in 1999. He has functioned as the Acting Chief Justice of Delhi High Court in 2010, Chief Justice of Guwahati High Court from 2010 to 2011, Chief Justice of the High Court of Andhra Pradesh from 2011 and 2012, appointed as the Judge of the Supreme Court in 2012 and retired in 2018. He has also been the Executive Chairman of the Supreme Court Legal Services Committee and later of the National Legal Services Authority. After retirement from the Supreme Court of India, he was appointed a judge of the Supreme Court of Fiji in 2019. Known for his keen interest in juvenile justice, Justice Lokur has been appointed as a one-man committee to suggest improvements in the workings of the homes and organizations under Juvenile Justice Act. He was also chairperson of Juvenile Justice Committee of Delhi High Court. Justice Lokur has formidable experience in alternate dispute resolution. He has been member of the Mediation Conciliation Project Committee of the Supreme Court of India since its inception in 2005 and later its chairperson. Justice Lokur has also played a pivotal role in the application of technology to judicial systems. He was judge in charge of the E-Committee of the Supreme Court of India for the computerization of all courts in India. We are indeed privileged to hear from Justice Lokur on these topics today. Presently, Justice Lokur has a professional chamber practice and is an independent arbitrator. He also writes frequently on legal issues of importance. He continues to have a keen interest in alternative dispute resolution mechanisms, child rights, legal aid, judicial reform, judicial education, and social justice issues. Justice Lokur is renowned for his fair rulings, and his notable judgments include striking down the Government of India's decision for minority subquota and the suspension and prosecution of the special CBI judge in the mining scam. Another mega contribution by Justice Lokur is that under his chairmanship as Supreme Court judge, the Citizens Commission of Elections has produced a report on free and fair elections in India. Justice Lokur's expertise and interpretation of the law continues to be ultra relevant to today's issues, including being appointed as a one-man committee to take steps for preventing stubble burning in Punjab, Haryana, and UP, which is a major source of pollution in the Delhi NCR's region. The Hindu newspaper, dated January 7, 2021, has quoted Justice Lokur as famously saying, "Judges should not be hypersensitive, and that it is high time judges sat down for an introspection." It is indeed a wonderful opportunity and a privilege for us to welcome Justice Lokur and hear his profoundly expert, contemporary, and humanitarian views. Thank you.
Thank you, Jayanti, for that excellent introduction. I'm sure you had trouble trying to make it concise and not speak about all his accomplishments and achievements. And when I was talking to Jayanti, I think just yesterday, we were discussing about how in any job, be it a Supreme Court judge, a medical doctor like Dr. Amresh, who's here with us, or any other profession, or Indira, who was a principal educationist, there are certain skills we bring to the function that we are performing. One is, of course, a functional skill, how good a teacher you are, or how good a doctor you are, or how good a judge you are. But there are some people who stand out because they go beyond the functional skill. They also think about how to improve the system in which they are working, they are a part of. They are able to critically view whether the way we are doing things are the right, is it the right way, or is there a better way? And constantly introspecting whether they are able to deliver what they are expected to. If a doctor, is he able to save lives, improve healthcare, improve the quality of life of the patients who come to him, and so on. And yet another aspect would be, and there's a great example in our state, I'd like to mention Dr. Kakarla Subbarao. The third aspect would be, how do they inspire the future generations? And in this example of Dr. Kakarla Subbarao, he has changed the face of radiology in the entire country. And so I personally, from what I have read about the Honorable Justice Lokur, he has all these qualities, and it is a great privilege and honor for us in FOSWL to have him speak to us about this very nagging problem. At some point in our lives, all of us have to knock on the doors of justice. But just like the other agency of our Constitution, which is designed to protect the citizens, we are mortally scared of these agencies, the police or the court. Because in the vernacular Telugu language, there is a saying which says, after a court litigation or fight, the guy who loses cries in the court, and the guy who wins comes out of the court and weeps, because he has spent his lifetime, all his resources in fighting the case. I think there has to be a paradigm shift and sweeping changes in the way justice is accessible, affordable, and delivered to citizens in our country. So on this important topic, we are very happy that Justice Madan Lokur, whom we've had the fortune of having as our Chief Justice in the erstwhile combined Andhra Pradesh, share his thoughts. And he also said he'll be happy to take questions later. My request is, please do not interrupt the speaker during the talk. Type in your questions into the chat box, either to me or Samridha Ghosh, who is the co-host. And after the talk, we will take them up. Justice Lokur, the floor is yours.
Yeah, thank you. Thank you, Subbarao, and thank you, Jayanti, for that wonderful introduction. Thank you to all the participants who are here today to hear about justice delivery in India and why it requires a makeover on an urgent basis. I propose to divide my talk into two sections. One section is to highlight some of the problems that are very obvious. We know what those problems are, and we know what the solutions are. The solutions are also very obvious. But it's not going to be only critical, because in the second part of my talk, I would like to suggest some solutions to the problems that are facing the Indian judiciary and how we can move forward in a more positive way. So it's going to be a mixture of both. Now, all of us know that as far as the judiciary is concerned, it is alive because of public confidence and because of public trust. Unless the people in the country have faith in the judiciary, they have confidence that they're going to get justice, they can trust the judges to be honest and persons of integrity. Unless that happens, our judiciary is finished. If there is some doubt about the impartiality of a judge, or the fact that the judge is corrupt, or the fact that the judge is biased, I don't think anybody will go to that particular court because they know what the result is going to be. So really, public trust and public confidence are extremely important for the independence of the judiciary. And today, although the judiciary has been able to maintain that public confidence and public trust, things have happened in the last couple of years, which have, in a sense, shaken up people's confidence to some extent on the independence of the judiciary. But that's a separate aspect altogether. I would like to focus now on some of the problems, some of the more obvious problems that we talk about, and which, of course, also relate to the lack of public confidence or the absence of public trust. The first obvious problem is that there are too many vacancies in the judiciary, and the obvious solution is fill up those vacancies. But it's not so simple. I will tell you what the facts are. As on 1st of March this year, 2021, 40% of the positions of judges in the high courts are lying unfilled, 40%. At the district level, where we are supposed to have 20,000 judges, about 20% of the positions are lying vacant. So there is a huge, huge gap. Now, the Supreme Court has delivered a judgment more than a decade ago, in fact, about 15 years ago, called Malik Mazhar Sultan, where they had laid down the schedule for filling up the vacancies in the district courts. They had said, for example, that on or before the 15th of January, you should be in a position to identify what are the positions that are going to fall vacant during the year. On or before 31st of January or 15th of February, you should put an advertisement in the newspapers that you're going to fill up all these vacancies. Then you have an examination, interview, so on and so forth. And before the end of the year, you fill up all those vacant positions. Now, unfortunately, what has been happening is that the judgment of Malik Mazhar Sultan is not being scrupulously followed. And that is why we are left with this 20% vacancies. Similarly, we've had 4 cases with regard to the appointment of judges in the higher courts, that is in the High Court and in the Supreme Court. In one of them, in judges case number 2, the Supreme Court said that you know when a post is going to fall vacant. You know when a judge is going to retire. I mean, his date of birth is known, his or her date of birth is known, age is known, and you know that there's a vacancy that is going to fall. So why don't you make a recommendation for filling up that vacancy 6 months in advance? Why do you have to wait for the last minute or maybe even beyond the last minute? Again, that is not being done. So recommendations are made after the judge retires or just a few days before the judge retires. And, that is the reason why we have 40% vacancies. So the mechanics are available, but they are not being implemented. Today, the government is talking about something called the All India Judicial Service. I don't know too much about it because it's not available. What is the scheme is not available in the public domain. It seems to be shrouded in some kind of a mystery. But the government says that, oh, we are going to conduct examinations in the same way in which examinations are conducted for the IAS and IFS and so on. Whether it will work or whether it will not, I cannot say, because like I said, I do not know too much about this. In fact, I do not know anything about this because it's not there in the public domain. The second problem that all of us keep talking about is that there are far too many cases that are pending. Now, again, the reduce the number of the solution to that is reduce the number of cases that are pending. Now, how do you achieve that? I'll tell you what the facts are. The facts are that in the high courts across the country, and this is from the website of the e-courts website, which I saw today, 48.3 lakh cases are pending in the high courts. 3.79 crore cases are pending in the district courts. So today, we have 4.27 crore cases that are pending in the country. I think it's just gone beyond all limits. I remember, being scared of the pendency when it was about 2.5 crore. Today, we are talking about 4.27 crore. It's just gone completely out of hand. What is the result of this? The result of this is that there are important cases, important constitutional cases, which are not being taken up. Important cases concerning civil liberties, which are not being taken up. Important cases pertaining to fundamental rights of citizens, not being taken up. On the flip side, you have 69% of the people in jails across the country are under trials. They're awaiting a trial, 69%. Prisons are overcrowded because trials are pending, appeals are pending, people are in jail. It had gone up to 112%. That was the national average, 112% occupancy. Thanks to the COVID, it came down when parole was being granted a little more liberally, bail was being granted a little more liberally because of health issues, not because the persons deserved it, but because of health issues. But now that people are being asked to come back, it has again started mounting up, and it will come back to more than 100% occupancy. I did a small comparison between California, which is the largest state in the United States, and Bihar, which is not the largest state in India, but probably number 3 or 4. The reason why I took up Bihar and California is that California represents 12% of the population of the United States. Bihar represents 10%. So more or less in terms of percentage, it is equal, although there is a huge population difference. California has a population of 39 million, let's say 40 million. Bihar has a population of 120 million, so 3 times more than California. Now, in California, 58 lakh cases are filed every year. I'm absolutely 100% sure that this is nowhere near the figure of cases that are filed in Bihar. It is much, much less. In fact, I would be surprised if 58 lakh cases are filed all over the country in a year. So we have in California, perhaps, I'm not 100% sure, perhaps the same number of cases that we would have filed in India in 1 year. That's 58 lakh cases. Bihar has 1,936 judges. California has 2,000 judges. The population of Bihar, like I said, is 3 times more than that of Bihar, 3 times more than that of California. In Bihar, the budget for infrastructure is 795 crores, which is 0.51% of the expenditure of the state of Bihar. This is only on infrastructure. In California, they have a budget of $3.6 billion, and this does not include infrastructure. So we have this huge gap, in terms of resources. And that is the reason why we are just unable to cope up with the problems that are facing our judiciary. And that takes me to the third aspect, which is the budget. What is the financial situation? The budget or the amount of money that is spent on the judiciary, according to the India Justice Report, which was released about a month ago or maybe 2 months ago, the union government spends 0.08% on the judiciary. That is 8,000 crores. The states, of course, spend separately, but this is the contribution of the government of India. And that includes the Supreme Court and a couple of high courts, which are getting grants from the government of India. Now, a study that was conducted in 2016 indicated that judicial delays, the estimate loss in terms of GDP because of judicial delays is 0.5%, which works out to 50,000 crores. So judicial delays result in a loss to the country of 50,000 crores every year. In 2016, this was the year when the study was conducted, the GDP of India was 120 lakh crores. So you can imagine, how much of a loss there is that is being caused because of delays. And delays because of vacancies, because of a large number of cases, because of budget not being made available to the courts. The fourth immediate problem that is facing and which we talk about is a lack of infrastructure. What is the solution? The solution is provide better infrastructure. Let me give you some facts in this regard. A study was conducted recently, last year, of 665 court complexes across the country, of district and sessions courts, not of the courts of the magistrates and so on, but of district and sessions judges, 665 courts. It revealed that 100 court complexes did not have any washrooms for women. That's the kind of infrastructure we are talking about. And when we talk about, diversity, having more women in the judiciary and so on, this is what the reality is. 100 court complexes out of 665 do not have any washrooms for women. Only 40% of the washrooms are fully functional. That is, that they have washrooms for women and they have running water. Only 40% out of 665. As far as the litigants are concerned, the situation is even much worse, right? So it's hostile. The environment, the infrastructure is hostile as far as judges are concerned. It's hostile as far as litigants are concerned. Bihar, I had mentioned, the budget for infrastructure is 795 crores, which is 0.51% of the total expenditure of the state. And this was noted by the Supreme Court in a decision rendered just last year on 28th of February 2020. Things have not changed. So we are talking about less than 1% investment in the judiciary. Most courts, well, if not most, many are dingy, problems of electricity, they're damp, seats are not available for litigants, furniture is lacking. Many of them are in rented premises, so the landlord doesn't bother about the upkeep, and there is no money that is available for the upkeep of those premises. It is in these conditions that our judiciary is working. The fifth immediate problem is the difficulty in access to justice for the marginalized group. Again, immediate solution, make access to justice easily available. Now, who are the kind of people who get justice? We've come across in the recent past about an influential journalist getting justice within 24 hours. What about some other people? Last week, the Calcutta High Court wrote a judgment about a citizen of Nepal who was in jail for 41 years. And he was released last week because the Calcutta High Court came to the conclusion that he was mentally unfit to stand trial. So the trial had not taken place for 41 years. His mental age was found to be 9.5 years. Now, can you imagine? 41 years ago, this person was put in jail and people did not even realize what his mental condition was. You've had recently again, the Allahabad High Court acquitted a person of rape after he had spent 20 years in jail. Out of that 20 years, his appeal was pending as a defective appeal for 16 years. So therefore, it could not be listed. 20 years later, he was told that he was acquitted. 127 persons were acquitted under provisions of, they were accused of an offense under the Unlawful Activities Prevention Act. They did not spend too much of time in jail, but out of those 127, 5 of them died. Now, it's not only a question of being in jail, it's a stigma. And many of them said that, listen, society just abandoned us because they said that you belong to an organization which is a banned organization. How do you expect us to interact with you? You had a case where a person was acquitted of an offense of adulterating turmeric, haldi, after 38 years. Right? Then you've had, again, last week, the Bombay High Court, in an uncontested case, nobody was contesting it. Letters of administration had to be issued about the administration of a dead person. A decision taken after 31 years. Now, this is the kind of problems that we are having. So you have one section of people who get justice almost immediately. And on the other hand, you have persons like this who have to wait for decades. Habeas corpus petitions are not being heard. Persons are in jail without a trial. Children have been put in jail without a trial, and their cases are not being heard. Activists who speak up, dissenters who speak up, they are being arrested on charges of sedition. They are being arrested on charges of being probably terrorists under the Unlawful Activities Prevention Act. You go to a judge and say this person is guilty of sedition. The judge will think 3 times before giving bail to such a person. If you say this person is a terrorist, the judge will think 3 times before giving bail to such a person. So the principle of bail, not jail, which we have been following for decades, has been forgotten. And that is what is resulting in 69% being under trials and overcrowding in prisons. These are 5 immediate problems that we are facing in the judiciary. And well, like I said, there are immediate solutions, but there are huge challenges for these to resolve these problems. I will come now to the second part of what I would like to say, which is providing solutions other than those which are obvious. Like I said, filling up vacancies, obvious solution. Reduce the number of cases, obvious solution. So I would like to look at a larger picture. Number 1 is to enhance the quality of judicial education. We have a wonderful judicial academy, National Judicial Academy. Every state has judicial academies. What is their contribution? how are they fostering judicial education? We still have, and we've had in the recent past, we've had cases where gender issues have been dealt with in a very retrograde manner, if I may say so. The Attorney General for India had remarked, in fact, he had told the court that judges need a course in gender sensitization. So judicial education is one area where we can actually think of providing quality justice, at least training the judges to provide quality justice, judgment writing, eliminating bias, gender sensitization. All these are aspects of judicial education that we must look at. Second, we must look at alternative dispute resolution mechanisms. The law provides for mediation. The Civil Procedure Code provides for mediation. The Criminal Procedure Code provides for plea bargaining. We are not using it. Mediation, we talk about it, not being utilized in the manner in which it should be utilized and in the scale in which it should be utilized. Plea bargaining is even much worse off. I don't think there has been any serious attempt, except one in Delhi in 2008 when we had initiated plea bargaining in the district courts, not being utilized. Juvenile justice, diversion, not being utilized. Why do children have to come to the criminal justice system? Why do they have to enter the justice delivery system? Can't we have diversion? Not being utilized. So we have these tools, but we're not utilizing them. Again, coming back to the United States, they say that hardly 5% of the cases go for trial. What is the reason? The reason is plea bargaining, the reason is mediation, the reason is diversion. We are not utilizing these resources, which are available to us, by the way, under law, which do not require money. You don't need money for mediation. You don't need money for plea bargaining. It can be done free, but we are not doing it. Technology, that's number 3. We are not using technology at all for research and for evaluating performance. The National Judicial Data Grid, which was inaugurated quite some time back by the E-Courts Committee, has opened the door for making some objective assessments. The data is available, but not being utilized. I remember participating in a regional conference of the National Judicial Academy in Jodhpur, where the audience was shown, which included judges from 4 or 5 states, including High Court judges, about a particular case in a particular state where 113 adjournments were taken over a period of 3 years. Can you believe it? It had no impact on the judges of that High Court. Why? Perhaps they felt, well, how does it matter? So what if there are 113 adjournments? So if there is no will to improve, how are things going to improve? I mean, if you say, all right, it doesn't matter if there are 113, so what? In other cases, there are 50, 60. And this is an exceptional case, maybe 113. But then you have to find out the causes. A war room can be set up to monitor case disposal, to monitor the performance of a judge. We have to use computers for constructive purposes, not as an electric typewriter, which is what is happening. Again, last month, some academics from the United States conducted research on the data that is available on the National Judicial Data Grid, 8 crore cases. They did research in the United States, and they came to the conclusion that there is no caste bias in the district judiciary. Very good. How about us doing research for the benefit of our judiciary? We don't do it. So technology is there, resources are there again, computers are there, all the courts are computerized. We're not using it. Even during the pandemic, we were not able to utilize the video conferencing facilities that are available in all the courts. Number 4, case management, something which you don't look at. Many years ago, 2005, the Supreme Court said, please look at case management. Justice Jagannath Rao, an eminent judge from Andhra, from undivided Andhra, was asked to prepare case management rules, which he did, accepted by the Supreme Court, not implemented. I remember, I can tell you the value of case management. I remember a judge from the United States who had come, and he gave a lecture in the Delhi Judicial Academy, and he said that he is doing case management. And after the lecture was over, somebody asked him, how many cases do you have on your docket? He said, I have 300 cases on my docket. So the judicial officers, sniggered, laughed. And they said, you have 300 cases on your docket, so that's why you can do case management. We have 1,500 cases on our docket. How do you expect us to do case management? I then asked the judge. He said he had been doing case management for 3 years. I asked him, I said that 3 years ago, when you started case management, how many cases did you have on your docket? He said, I had 3,000 cases on my docket. In 3 years, he brought down the figure from 3,000 to 300. And here, our judges were complaining about 1,500 cases. This is the value of case management. We are not doing it, in spite of case management rules being available and accepted by the Supreme Court. Number 5, court managers. The 13th Finance Commission said that you should have court managers. Why? Because the courts need professional assistance. Judges are supposed to judge. They're not supposed to manage, various things that are going on in the courts. That's for court managers. You can't have a heart surgeon running a hospital. You have persons who are qualified in hospital administration. It's a task which has got nothing to do with surgery. So management of the court has got nothing to do with judging. But, we're not looking at it. What will happen to a hospital if critical medicines are not available? Supposing, oxygen is not available. Will anybody ever go to that hospital? Now here you have a situation where justice is not available. Why should people come? If they are told that, listen, you have to wait for 10 years. Can you go to a hospital and be told that, if you want oxygen, we'll give it to you after 10 years? Nobody is ever going to think about it. This is the problem that we are having. We need to have court administrators, court managers. I had discussed this with Nalsar, the Law University in Hyderabad, in Justice City. Well, hopefully they might take it up and introduce some kind of a course on court administration. Number 6, Gram Nyayalayas. There's a law passed by Parliament. It was introduced in 2009, 2nd of October, Gandhi Jayanti, 2009. More than 10 years have gone by, not implemented. There are 6,614 block panchayats or panchayat samitis at the intermediate level. The plan initially was that by 2017, there will be Gram Nyayalayas, 2,500 Gram Nyayalayas at this intermediate level, 2,500 out of 6,600 by 2017. What happened? Only 320, the number is not very clear. Some people say 320, some people say 395 Gram Nyayalayas were notified out of the requirement of 2,500. And out of that 300 plus, only 204 were said to be functional. UP, Uttar Pradesh had a target of 822 Gram Nyayalayas. 113 established, only 14 are functional. Gram Nyayalayas are supposed to be at the grassroots level. People don't have to come to courts. They just go to the Gram Nyayalaya, which are also, by the way, mobile courts. They deal with petty issues. The law requires that if you're not satisfied with the judgment given by the Gram Nyayalaya, you file an appeal. That appeal will have to be decided within a period of 6 months. The estimate is that if Gram Nyayalayas are functional, 50% of the caseload in the district courts will be wiped out. So from this figure of 3.79 crore cases, 50% you take them out, you will have what? I don't know, maybe 1.5 crore cases pending. Now, again, this is Gram Nyayalayas are doorstep justice. They're not hidebound by Procedure Evidence Act and all that. It's not there, but the resource is available, not being utilized. Why? I don't know. Number 7, process re-engineering. Now, that I think is the need of the hour. We are following rules that were set up decades ago by the British. We are still following them. Delhi follows rules that were set up by Lahore High Court. Lahore High Court, by the way, has revised their rules. We have not. But we're still following those rules. I remember in Shillong, one of the rules was that a witness, to get the money that he has spent, transport, bus fare, to get that money, he has to come again to get the money. So he has to take 2 trips, one as a witness and second trip to get the reimbursement of the fare. Why can't it be done in 1 trip? And why does the rule require 2 trips for this? In one state, going on a horseback to serve process is perfectly all right. Now, how many process servers do we have who go on horseback? Today, we are looking at process serving through mobile phones, interstate mobile services, process services. And we are talking about people going on horseback. Why are we not looking at our processes? Our processes have failed us for whatever reason, either because of the volume of cases or for some other reason. Let's look at them. Why go to something that was there 70, 80 years ago? Things have changed in the last 70, 80 years, but not our rules. We had, I can tell you, when I was in Hyderabad, there was a report that was prepared about maybe a year or 2 earlier by the Administrative Staff College of India. Excellent report, not implemented. One of the learned judges mentioned to me that, there is this report that has been prepared by the Administrative Staff College. Can we think about implementing it? I said, sure. Do we have a copy? I was told that it got burnt in the fire in the High Court. I talked to the Administrative Staff College. They said, yes, we have a copy. We'll give it to you. They also said that, by the way, you have to give us some money because we have done the work for you and we've not been paid. I said, fine, I'll give you the money. The High Court will give you the money and then you give us the report. Not implemented. There are reports given by Bajaj Institute of Management about the Supreme Court, not implemented. Faculty of Management Studies, Delhi University, not implemented. IIM Ahmedabad, not implemented. So, we can go on and on having reports like this. We can go on and on having law commissions. But unless we look at the future, how are we going to improve? Number 8, imposition of costs. We talk about frivolous litigation pending for 10 years. Why? Because frivolous litigation is there. Courts are jammed with all kinds of cases. Supreme Court said, again, in 2005, 15 years ago, that you must impose costs. Be realistic. After all, coming to the court is not cheap. Persons have to spend money on lawyers, they have to spend money on transport, they have to spend money sometimes on accommodation, they have to spend money on typing, miscellaneous things. Why are they being dragged into litigation? Why is the government filing frivolous appeals? Every case decided against the government, there's an appeal filed. The government is the biggest litigant in the country. What are the facts and figures? Nobody knows, but everybody believes that the government is, and it must be, the biggest litigant in the country. The court grants bail, file an appeal. Why? How about imposing costs? So that the person who is dragged to court unnecessarily is at least relieved of the burden of having to spend thousands of rupees on a litigation which that person did not invite and that was thrust upon that person unnecessarily. We're not looking at it. In Bangladesh, they have a curse. And the curse is that may you be involved in litigation. So if you want to curse somebody, you say, I hope you get involved in litigation. It's happening in India as well. Time stands still. So once you're in litigation, wait either for 10 years or spend a lot of money, move applications for early hearing and so on. Whether you get something, nobody knows. Number 9, social audits. We are not looking at social audits at all. At our institutions, I'm not talking only about the judiciary, at all our institutions, we're just not looking at social audits. I conducted a social audit. I requested the National Law University of Delhi to conduct a social audit on the functioning of the Supreme Court Legal Services Committee. The results were shocking. Appeals had not been filed in the Supreme Court for 14 years. Persons had undergone life sentence and an appeal had not been filed in the Supreme Court. And I'm not talking about 1 or 2 cases. Out of something like 2,300 cases that were pending, there were about 700 plus cases where appeals were not filed. The staff and the consultants contacted the litigants personally on telephone and said, do you want to pursue the matter? Many of them said that, listen, we have waited for so many years. You have done nothing. We have now engaged private lawyers. So out of that 700 plus, there were 350 or something who said, sorry, we're not interested in your, legal assistance. And that is the Supreme Court Legal Services Committee. Ultimately, 400 appeals were filed on an expedited basis. And the judges naturally said, what is the reason for delay? And our lawyer had to tell the court that, well, there's been a very serious lapse. The court condoned the delay in all those cases. But why should that happen? This was disclosed by a social audit. Now, there are so many of our institutions, judicial academies. Let's conduct a social audit, find out what they are, what impact they are having on our judges. Is it improving their functioning? Is it improving their efficiency? What about legal services authorities? Is that having some impact? We should have a social audit, and I'm a great votary of having social audits for many of our institutions. And then we will know really what is happening. And solutions will come out. Like I mentioned about the Supreme Court Legal Services Committee, the solutions came out. Appeals were not being filed, file them. We put systems in place so that this doesn't happen again. One of the problems was that, evidence was being recorded. behalf of a litigant, please ensure that the evidence or the testimony of the witnesses is translated into English. So these solutions will come out through these social audits. Number 10, house cleaning exercise. Hundreds of cases are just lying over there for no rhyme or reason. I mentioned to you about Allahabad High Court. For 16 years, the case was lying under defect while that man was in jail. If that house cleaning exercise had taken place 16 years earlier, the matter would have been decided. We had such a huge number of dead files, cases decided but not weeded out in the Supreme Court, that when we undertook the exercise, a new hall was inaugurated for the benefit of lawyers, something which the lawyers had been demanding for many years. It was just full of files. Just a little bit of house cleaning exercise and you had a new hall. There are hundreds and hundreds, let me tell you, hundreds and hundreds, if not thousands of cases pending in courts which are completely dead or which can be disposed of in a matter of a few moments. Like that uncontested case which was pending in the Bombay High Court for 31 years. Over in 5 minutes. But we are not doing that house cleaning exercise. So once something comes to the court, it remains there. Delhi High Court, through this process of house cleaning in the heart of Delhi, pretty close to India Gate, which is virtually the center of Delhi, 50,000 square feet was emptied out through this process. So when we talk about shortage of space, why is there a shortage of space? Because there are too many cases pending. Do a little bit of house cleaning exercise, you'll get the space. The last point that I want to mention by way of a solution is to brainstorm. Unfortunately, our judiciary is not brainstorming. It must brainstorm, it must introspect, it must brainstorm again, it must introspect again, it must do it a third time, it must introspect a third time. These are problems that are facing us, staring at us in the face. There are solutions, I have given you 10 solutions, which are staring at us in the face. Why is it that we cannot debate these solutions? I'm not saying that what I'm telling you is right and that these are the only solutions. They may not be the only solutions. They may be much better ones. There may be other problems which I have not adverted to. Why can we not just sit down across the table, brainstorm for a full day, once, twice, 3 times, find solutions, implement them, and if there are problems, sort them out. If the government is not giving money, request the government to give money. If the government is not giving court buildings, request the government to give court buildings. I had gone to Chittoor and I met a judge over there, and she said, in the monsoon season, I don't hold court. I said, why? Very strange, that in the monsoon season you don't hold court. She said, the roof above my head is leaking. So when it rains, the water falls on my table. There you are. So you have these kind of problems which can all be sorted out. I'm absolutely confident that all of them can be sorted out through brainstorming and through introspection, and having a will to reform. Otherwise, things will go on like this for the next 100 years. Unless there is a will to reform, things won't change. I believe that we are not going to get a second chance. If we don't do it now, it might be too late. 4.27 crore cases that are pending, in my view, is pretty close to too late. It may still be too late, but if it's not, it's pretty close to too late. And if you don't do anything now, if you don't have that makeover now, you're not going to get a second chance. So thank you very much, and all the best.
Thank you so much, Justice Lokur. I think everybody would agree that you held us spellbound. Just the calm way you have articulated the problem and also, dissected the problem and possible solutions. There are a lot of questions, and me and Samrita Ghosh will alternate. I will start by alluding to point number 7 of the 10 or 11 you listed. Taking an analogy from the healthcare, are all these addressing the symptoms and not the cause? In the sense, it is known that we have adopted the British legal code and legal system. Is the justice code by which our judicial system operates itself in need of an urgent makeover? For example, one of the participants has listed, will a jury system like in the US help reduce? There are archaic laws, outdated processes which require business process re-engineering, as you have said. Is the very fundamental doctrine of justice delivery on which India operates in need of a makeover?
Yes. Yes. You see, like I said, we need to have a fresh look at our processes, right? I think any organization worth its name, looks at how things are happening. Are we just pushing files, in the bureaucracy, going from one place to another place, one table to another table? In the judiciary, is that what we are doing? From one court to another court, another court to another court, 4 layers. What about the movement of the files within the registry? I go file a case, somebody says, 3 objections. This is not, this typing is not correct, this is not correct, that is not correct. I say, all right, I take it back, remove those 3 objections, I go there, he says 3 more objections. Now, why couldn't you tell me all those 6 objections in the first instance? Suddenly you manufacture 3 more, right? Why can't this be taken up? Why does the file have to go from one place to another, remain in effect for 16 years? Can't it be done immediately? All right, give a day, give 2 days, 3 days. In the case of that journalist, it was done within 24 hours. In fact, a defective petition was listed and heard by the Supreme Court on Diwali or a day before Diwali. If it can be done there, why can't it be done for others? What about the poor who have to come personally on many occasions because they can't afford a lawyer and they have to stay? And you tell them that, no, come after 2 days, I will tell you what are the defects. Then after 2 days, that poor person goes and he's told that, no, now there are 3 more defects. So processes have to change. But if not change, at least have a fresh look at them. Something like a certified copy. Today we can use digital signatures. We had an incident recently where a person was not released from from jail because the jail superintendent said, I have not received a certified copy. But he had received a digital version. He said, no, I want a hard copy, certified. I will not release this person. Why should that happen? So we need to think about this. I'm not saying that, the rules are terrible. Some of them are. Some of the rules are terrible. But let's look at them. Come out with something more, 21st century.
Samrita, I'll take one more and then you can bring in the next lot. The other question, I'm bunching a few observations together to make it one question. There is a general perception that the judges in the various courts of the are largely, quote unquote, responsible because A,
Sorry, I didn't get quote unquote. What did you say?
they are responsible for the delays.
Okay, judges are responsible for the delays. Yeah.
Yeah, and the reason being, we still have the court vacation system. Number two, there is no, how do you measure a judge's efficiency? Number three, there is no benchmarking of how many judgments a judge has to deliver in a day or a month or a year, and so on and so forth. How true is this perception? And they're talking about from the trial court right up to the Supreme Court. It's across the board. I mean, some of us know it is a misplaced perception because, as you have rightly described, infrastructure issues, there are issues of political interference, there are issues. But in the public mind, this is what is popularly perceived. Respond to this.
Yeah, you see, so far as court vacations are concerned, I can tell you from personal experience that judges work extremely hard, including on Saturdays and Sundays. Now things like legal aid, for example, Lokur adalats, right? Judges are involved in them. You take out, some of these activities which they are doing in, in their administrative capacity. Perhaps then you can speak about, court vacations being very long. But as long as you saddle them with all this, they have no option. Judges have complained to me that Saturdays and Sundays we have to attend, classes, judicial education. What time do we get with our family? Other judges have complained to me, Saturdays and Sundays we are busy with Lokur adalats or we are busy with judicial education. When do I write my judgment? So these are things, it's nice to say that judges have a lot of vacation time. But how many of them actually use that vacation time? Many of them are busy writing their judgments, catching up with, their reading, writing their judgments. Even during vacations, they may go out for a holiday for about a week or so, but that's it. So really, there is this perception, I'm not denying it, there is this perception that, they're having too many holidays. But they have cut down the number of holidays in many places. I can tell you Supreme Court has cut down its vacations. Delhi High Court, I know, Andhra High Court, undivided Andhra had cut down its vacations. Many of them have. But there is no compensation for working on Saturdays and Sundays. There is no compensation for reading files at 11 o'clock at night so that you don't spend time the next day in court. Law clerks who come to assist the judges don't go home before 9:30, 10. And they're just supposed to be assisting the judges. I mean, they're not even judges. So it is, let me tell you, very hard work. It looks from the outside, these people have a lot of vacations, they must be enjoying themselves. It's not like that. And the second part of your question, sorry, what was that?
In terms of benchmarking.
Okay. Yeah, again, when I talk about social audit, you can include other aspects, performance audit, for example. Right? There are ways and means of finding out whether a judge is doing his work diligently or not. The National Judicial Data Grid gives information about every judge in the country. Every judge in the country. But who takes the trouble of going through it? When you're a High Court judge, you are allotted a district and you are the judge in charge of that district. You have to see that, things are going on well, work is being carried out and so on and so forth. If there are any complaints, if there are any grievances, they're taken care of. Fine, judges do that, no difficulty. How many judges say that, listen, we have gone through the National Judicial Data Grid and I find that 3 of you have not been doing your job properly. Or 3 of you are, not listing enough cases or granting too many adjournments. What about the judge who granted 113 adjournments? May not be one judge, maybe 2 or 3 judges. Any action taken? No action taken? So when this information is available and you don't utilize it, what more do you want? If you have a better system, fine, introduce that better system. But until you have that better system, at least utilize the system that you have. Any judge, you look up the National Judicial Data Grid, you can find out about any judge in the country. But somebody must take the trouble. That's why I had mentioned about a war room. You can set up a war room in the High Court and say that, listen, I'm going to monitor. See how you're performing. How many cases have you decided? How many statements of witnesses have you recorded? How many witnesses have you examined? How many adjournments have you granted? How long have you heard a matter which would normally take 5 minutes? You heard it for 1 hour. Why? So the tools are available, resources are available. They have to be utilized. Benchmarking can be done, provided you analyze the data available. You just can't say that, a person should dispose of 50 cases in a month. On what basis are you saying 50 cases? Why not 40? If you know that this is the capacity of the person, or this is the capacity of a large number of judges, that motor accident cases, a judge on an average disposes of 50 cases in a month, then you can tell me that, listen, judges across the board are disposing of 50 cases in a month of motor accident cases. Why are you disposing of only 20? Because the benchmark is 50. But until you set that benchmark, and that benchmark can only be set through analysis, not arbitrarily. Until you set that benchmark, you can't fault the judge.
Thank you. Samriddha?
Yeah.
Subbaragaru.
Who is this?
I am Dr. Krishnamurthy.
Can you please hold on? Let Samriddha take up the next question, please.
I have few suggestions and questions.
Yeah, we'll come back to you.
Yeah.
Samriddha?
Hello, Mr. Yeah. Hello. It's lovely to hear you. There are 2 questions. They're similar, so I'm going to club them. One is by Mr. Amresh and the second one is by Jayanti Sethuram. The first question is, can modern technology like artificial intelligence and data analytics help us monitor justice delivery? And the second question, which is somewhat related, is what would be your view on private sector partnerships and owning some aspects of the technology in the judicial system, such as data archival and mining? How does the private sector make inroads here for a partnership? And also, are there some states where we have seen some proof points for such effective partnerships?
Okay. Now, so far as artificial intelligence is concerned, the expectations are very, very high. A judge thinks that, if artificial intelligence is introduced, the computer will write the judgment for me. That's not going to happen. No computer can do that, right? But we have introduced machine learning to some extent. Again, there was a problem. You have very petty offenses like traffic offenses, jumping a red light, or speeding. So through the e-courts in August 2018, we had introduced something which is called a virtual court. Not the kind of virtual courts that we are talking about today. virtual courts that we are talking about today are actually online courts, but this is a virtual court. So supposing I jump a traffic light, the policeman will either, take a picture of my driving license or will, feed the information that this person, jumped a traffic light, and it will go directly to the virtual court. I can go to the virtual court. It's open 24 hours in a day. And I can either plead guilty and pay the fine. We had said put the minimum fine, so that people are encouraged to use this in the first instance. But if I say that no, I did not jump the traffic light, or I was not speeding and I want to contest it, I am entirely free to do that. The case will then be transferred to the magistrate. That was the first step. The second step postulated was that supposing I'm a repeat offender, then instead of the minimum fine, it will be slightly more. But anyway, that was the second step. Introduced in 2018, August. Now, apart from Delhi, no other state decided to take it up. Through the E-committee, we requested them that, listen, try it out. It will save a lot of problems. Recently, Maharashtra has taken it up. Tamil Nadu has taken it up. Karnataka has taken it up. Apart from these three states, no other state has taken up this concept of virtual court. What is the advantage of a virtual court? The advantage of a virtual court is that one person, one judge, who will, at the end of the day, sit down and say that, well, these are the ones who have pleaded not guilty, sent to a magistrate. These are the ones who have pleaded guilty. This is the fine. One judge can handle the entire state. So in the state of Maharashtra, if you have 40 judges, one judge in each district, or maybe two judges in each district, but I'm taking the minimum 40 judges, that work of 40 judges can be done by one person sitting on a computer. So also in Tamil Nadu, so also in Karnataka. So you have 39 judges available for doing other work. But this is one of the great advantages of technology, but not being picked up by other states. Why? I cannot say. So artificial intelligence is, something which is way beyond that. How it is actually going to work, I don't know. I don't know of any judiciary anywhere in the world which is using artificial intelligence for judging. You can, a lot depends on the algorithm. You can have a biased algorithm. I can have a bias against a caste. I can have a bias against a region. I can have a bias against whatever, language, whatever. If the algorithm is not correct, you're going to get a biased result. And that biased result is going to go on repeating itself. They say that in the United States, there is a bias in the judiciary through the computers against persons of African origin. So once that bias gets in, it gets compounded. And it will continue. Okay. You can predict. A few years ago, I think again, probably in 2015 or 16, the European Court of Human Rights, they fed in a lot of judgments, and the computer was asked to analyze those judgments and give a decision, yes or no kind of decision. There was an accuracy rate of about 79%. So in 79% or 69%, I'm not very sure. In that many number of cases, the computer and the court agreed on the decision. But 20% is a lot of disagreement when it comes to liberty. If 20 persons are put in jail, 20% of the people are put in jail when they should not be put in jail, you're asking for a problem. So artificial intelligence really, it's not being used as far as I know. It can't be used except machine learning to some extent, to a pretty large extent, but then we have to be ready for it. Second, public-private partnership, yes, it can be used. It should be used. That's what court managers are all about. They need not necessarily be persons belonging to the registry. They can be anybody. But they have to be managers. It was tried out during the 13th Finance Commission. I tried it out in Andhra Pradesh. It worked for some time, but there was a lot of internal resistance. Judges said, "Oh, why is this fellow interfering in my work?" So it can work. It needs, greater understanding, but it's possible. I am fully in favor of this public-private partnership to a limited extent, not for everything, but in the registry and for administrative duties, yes.
Thank you. Dr. Krishnamurthy, I'll come back to you. We have another 10 minutes for questions and then we'll have to wrap up. I know there are many. I'm combining a few questions now relating to why is it that so many corrupt politicians, who are public corrupt, amassed wealth, are free to go on bail in spite of strong charge sheets being filed against them and convicted, they're served in jails, whereas a common man cannot get bail. And people are even allowed to contest elections and hold electoral offices. And how is this tied to the allegation that there is corruption levels of the judiciary itself? These politicians to play. And a third question is, why is the judiciary so helpless that it cannot get what it needs to function from the government? When a public interest litigation can be filed at the drop of a hat for any frivolous thing, why are they not being filed for such important things as what you have mentioned? Lack of infrastructure, lack of power, and so on.
Okay. Now, bail for politicians or corrupt politicians, really it depends on each case. It depends upon the investigating agency, right? There are so many cases. There are so many cases where the investigating agency has won. They have prosecuted the wrong person, right? That's why you have acquittals. Or there is shoddy investigation. There are any number of judgments where the courts have criticized, whether it's the High Court or whether it's the Supreme Court, they have criticized the investigation, that the investigation is biased. So really the problem starts at the level of the police or at the level of the investigating officer. And the investigations can be manipulated. We know that. If the investigation is manipulated, you may know that the person is corrupt or you may believe that the person is corrupt, but the evidence does not show so. Why is the evidence lacking? The evidence is lacking because the investigation is faulty. There has been a case of a politician whose case had to be transferred out of the state to some other state. And witnesses were examined, they gave their testimony, that politician came back to power, and all those witnesses, not all, but most of them, were recalled for examination. And when they came back to the court for the second time, they said, "Oh, we didn't say this." They went back on their testimony. Why? Because of the influence of that politician. It's a recorded case. So systems can be manipulated. It's not something which happens only here. It happens in other parts of the world also. So the systems can be manipulated, but it has to start from the investigating officer. And if things go wrong along the way, then you'll get a wrong judgment. Second, you said about why the courts cannot get what they want in terms of finances and so on and so forth. Many years ago, when the American Constitution was being drafted, one of the persons, they wrote, many of them, some of them wrote the Federalist Papers. Alexander Hamilton wrote over there very famously. He said that the judiciary is the weakest branch of the government. It doesn't have the power of the sword. It doesn't have the power of the purse. Now, then what is the judiciary to do? If it passes an order, it has to be implemented by somebody else. If that somebody else says, I'm not going to implement the order, what are you going to do? The judiciary can't go there after that person with a gun and say that, listen, you better implement my order. Right? The judiciary has no money. It doesn't earn anything. The taxes don't go to the judiciary. And that's why the constitution maker said, all right, we must have a consolidated fund. But like I said, budget is important. We don't plan our budgets. We don't say that, listen, I want this much of money for this purpose. We say that, listen, I want 100 crores this year. Next year, when I have to prepare a budget, I will say, all right, 10% give me extra, 110 crores. Third year, I will say, give me 10% extra. Why? Because there's inflation and so on. But do I have a plan in mind? I don't have a plan in mind. The judiciary doesn't have a plan in mind. So it can't ask for the money. And when money is given, they don't know how to spend it. 13th Finance Commission gave 5,000 crores. Only 980 crores was spent over a period of 5 years. 14th Finance Commission gave 10,000 crores, not spent. So budgeting is a complicated exercise. Judges can't make budgets. That's why you need outside help. Yeah.
Samrita?
Yeah, this is the last bit of questions. This is about the speed. There are two questions about the speed of justice delivery. This by James Satay. Why is mediation not publicized enough so that many civil cases can be shifted out of the court? And a second part of the same question, or probably another question, is why are cases allowed to be adjourned more than 3 times? Can something be done about it so that it's faster?
You see, as it was mentioned in the introduction, that I've been a member of the mediation committee since its inception in 2005 until my retirement in 2018. We have had, several seminars, discussions, programs, training sessions to train people from different parts of the country to become mediators. We've had trainers programs. Unfortunately, there is some kind of a resistance to mediation. Now, one of the reasons that I think is that because the person who stands to lose says that, I'm prepared to fight it out in court because that is going to delay my loss. I will suffer a loss, but I will suffer it after 5 years. But today, if I sit down for mediation, I'm going to suffer that loss today. Why should I do that? That seems to be one of the reasons. Number two, many of the lawyers felt, and in Delhi, let me tell you, people have now got reconciled to it. Many of the lawyers felt that if we go in for mediation, matters get settled, we're not going to get any business. We are supposed to argue cases, but if the cases are going to get settled, what are we going to argue? So they were discouraging, mediation. But it took a few years for the lawyers in Delhi to accept mediation. In Delhi, it has been quite successful. More than 1.5 lakh cases have been decided at the lower level. But that's nothing, compared to the number of cases that have been filed over these years. So there has to be, a social pressure, so to speak. The judiciary alone cannot say that, listen, mediation is the best thing. Somebody will say, you may think mediation is the best thing. I don't think it's the best thing. So there are, interests. Lawyers have their own interests. Some litigants have their own interest. There has to be social pressure that, listen, it has to go in for mediation. Many people just take mediation, in contracts, commercial contracts, they say you go in first for mediation. They say, theek hai, we'll go in for mediation. Have a session for 5 minutes and say, I am not prepared to settle, go back and say that mediation is over. So it has to be something which it is a movement that has to take place from society. That courts are not the only places where cases can be decided. They can be decided through mutual discussion, through mediation. Second question about adjournments. Why more than 3 adjournments? Our civil procedure code says not more than 3 adjournments. Now, what do you do when a lawyer says that I've fallen sick? We know the state of healthcare in our country. If a lawyer says I've fallen sick, what do? You say, well, it doesn't matter. You stay in the hospital. I'm going to go ahead with the case. There will be a strike the next day. And the judge will get transferred out. So that kind of responsibility has to be there. Again, if you introduce costs, like I said, all right, first adjournment, okay, you're entitled to it, but I'm making it clear to you that you'll have to pay costs for wasting my time, for wasting the time of the other person also, for wasting the time of the registry. Pay costs. So these are matters which require a sort of a internal kind of discipline. That all right, if the law says not more than 3 adjournments, not more than 3 adjournments. There was a case, let me tell you, in England, where this person, the lawyer, was in the middle of cross-examination. And his client had told him sometime back that, listen, if the cross-examination doesn't finish by day 5, I will not be able to pay you for day 6. So the lawyer knew that the cross-examination is not going to finish by day 5. He wrote a letter to the Law Society of England saying that this is what the problem is. I will not appear on day 6 because I will not be paid my fees. My client has told me that. Would I be doing something unethical? Would I be violating the rules of the Law Society? The Law Society said, no, you will not be violating the rules. If your client is not paying you for the 6th day, you need not appear. The lawyer told the judge that I'm not going to appear from tomorrow. In the middle of cross-examination, judge said, that's all right, don't appear. But the lawyer who's instructing you, he has to continue with the cross-examination. Otherwise, I will close it. And that lawyer continued with the cross-examination. Try doing that in Delhi or in any part of India.
Thank you. Dr. Krishnamurthy, would you like to ask a question briefly? We are running out of time.
Yeah. Instead of question, I want to have a suggestions too. Number 1, why not courts have 2 shifts at least, 8 to 2 and 3 to 10? Number 2, why not a retired judge practice like a doctor and settle case instead of arbitration or anything? Judge can practice as a private judge so that clients can go and pay more fees and get the justice done. And that should not be challenged. That's it. And so that if the second shift, which is crossing the 5 or 6 thing, you can charge more. Something like a evening clinic. Why not evening courts? Okay. That is my this, because you said there are 4.7 crores, which is nearly more than the population of the Canada. So many are pending. You see, when a doctor does 3 shifts in a hospital, why not quote at least 2 shifts? That's what.
Yeah, Dr. Krishnamurthy is the retired head of the Department of Radiology of APS RTC. If you're wondering why he's mentioning doctors.
Correct. Currently consultant at Vijay Diagnostic.
Yeah, thank you, Dr. Krishnamurthy.
Yeah, but let me tell you about evening courts. This was a proposal that was given in the 13th Finance Commission. We did implement it in Delhi. On my initiative, it was implemented in Delhi. It worked for some time. We said we are going to have only, uncontested cases, check bouncing cases, for example, where the value of the check is less than 500 rupees or less than 1,000 rupees, something like that. We will take up traffic challans. Okay, uncontested cases, we will take them up in the evenings. It worked for about 6 or 8 months. But after that, even during that period, lawyers began saying that, listen, we have to meet our clients in the evening. How do you expect us to meet our clients when, the evening court is on? We said that, listen, these are petty cases. Why don't you send your junior colleague so that he or she can argue that case, learn how to argue matters. No. But you see, the client has paid us the fee. Why should we send a junior colleague? Judges said, we have to write judgments. We have a family to look after. What are we supposed to do? So the scheme worked in Delhi for about maybe 8 months, maybe 10 months or something. And then gradually it kind of faded out. So it's not that it has not been tried. It has been tried. It could have been better managed. I suppose so. I'm not saying that what we did was the best. It could have been better managed. But that's where you need professional help. Unless you have that, what do you do?
Thank you, Justice Madan Lokur. There are several questions. Some have come to my personal window, some on WhatsApp. I'd like to end this with by sharing the thought of a couple of the participants in more on the lighter side, I guess. He feels that judiciary can get all the infrastructure it wants and more. If you take the recent examples of Telangana and Andhra Pradesh, Telangana has increased the number of districts to 33. And right now, there are district administration collectorate complexes being constructed on a war footing in all the 33 districts. Some have already come to, functioning stage. And similarly, he says in Andhra Pradesh, they have implemented something called village secretariat, and using a certain color scheme, they have started constructing or renting buildings and infrastructure for this village secretariat. So this participant says it's just a question of knocking on the right door. If these collectorates and village secretariats can come, why not such an important thing as court infrastructure? So this, I think all of us know why and how, but on that note, I'd like to end because 7:45 is our time. We have already exceeded by 3 minutes, but that only shows how people were engrossed and engaged in conversation with you. I'm sorry we are disappointing some of them because we can't take up all questions. Would you like to have say some final words, Justice Lokur, and then we'll close?
Well, I'd like to thank you. I'd like to thank all the participants. And with the final word that I would like to say is that, we need the assistance of everybody to make our justice delivery system work. I'm still optimistic in spite of the 4.27 optimistic, but all of us have to make an effort. You just can't have a handful of people making an effort. Thank you.
It has been a delight to hear you, and for me, especially the second time. Thank you so much for coming. Before I call on our secretary, Mr. Subhash Chandra Bose, incidentally, he is a former superintendent of CBI and now a practicing lawyer in the CBI court, to give a vote of thanks. I have an announcement to make. I sent out a questionnaire, FOSWL did, about the starting time of our meeting. Unfortunately, we received only about 40 responses. Most of you seem to prefer 6:30 p.m. as a starting time instead of 6 p.m. So if all of us agree from the next meeting, we can change it to 6. The difference is not much. I think the difference was 34% wanted to start at 6:30 and some 31% wanted to start at the current 6 p.m. But we go by majority, so we can start it at 6:30. Is that okay with all of us? You can type in the chat box or send me a private message. But we will notify you of the changed timing if it is changed from next time. and we will continue with our virtual meetings till all of us are vaccinated. May I call Mr. Subhash Chandra Bose, our secretary, to please propose the vote of thanks.
Thank you all for joining this 147th monthly meeting on Zoom. We thank the family members of Sri Venkateswararao Tipirneni for establishing an annual endowment lecture in his name. We also thank Sri Bindu Madhav Ivaturi for the annual logistics sponsorship for the month of March every year. It was very educational and inspiring to listen to Justice Madan Lokur's excellent talk on the topic Justice Delivery in India Needs an Urgent Makeover. His talk threw light on the many reasons for the huge number of pending cases in Indian courts and the possible solutions to address this problem. As was explained in the talk, delays in delivery of justice has serious and long-term consequences not only on individual citizens and corporations, but also on our country as a whole. It impacts our GDP, foreign investments, human rights, employment, and the happiness index of our country. This is an issue that warrants the serious and urgent attention of our lawmakers and judiciary. Thank you, Justice Madan B. Lokur, for answering our many questions. Thank you, Ms. Jayanti Seturaman, for introducing our distinguished speaker this evening, and Nihal Kovali for reading the prayer. And I thank Kaustubh for joining us from the USA and sharing your thoughts on your grandfather's illustrious and inspiring life and work. Thank you, Samruddha Ghosh and Sai Kiran Kamaraju, for assisting Sri Subbarao Tipirneni as co-hosts on managing the Zoom technicalities. We propose to continue with the Zoom meetings for the next few months till the pandemic abates after the vaccination program. Our forthcoming meetings for the next 2 months are as follows. On the third Saturday, 17th April 2021, Sri Guntur Nageswararao, Chairman of the Atomic Energy Regulatory Board, will talk to us on nuclear radiation technologies in the service of humanity. On the third Saturday, 15th May 2021, Ambassador Vinay Kamalapalli, former US Ambassador to Belize, will talk to us on why the USA continues to be the favored destination of investment and innovation. Once again, it was very nice to meet all of you this evening. Wish you all a good and safe weekend. Good night, ladies and gentlemen, till we meet again on the third Saturday of April for our 148th monthly meeting. Thank you all.
Thank you all. Good night, and thank you for participating. Bye-bye.
Subbarao, it was very nice. Subbarao, very nice.
Thank you, Nitya. Thank you. Good night, Justice Lokur. I'll talk to you later.